Welcome to Case by Case. This is a podcast brought to you by Floyd Zadkovich. This is Carl and Jane. I'm Luke Zadkovich.
Every episode, we read a case independently of each other. So jump on the podcast, we hit record. So what you get is our raw thoughts on that law.
And we're super excited with some of the guests we've got coming up on future episodes. So keep an eye out.
And if you like the podcast, all we'd ask is that you hit subscribe and share with your network. Okay, let's get into it.
Let's do it.
Welcome to Case by Case. This is a podcast brought to you by Floyd Zadkovich. I'm Luke Zadkovich. We don't have Callum on the pod today, but I'm pleased to say that we're joined by one of our associates in our London office at Floyd Zadkovich, Andriy Shalennyy. Andriy, how are you?
Hi, Luke. First of all, thank you very much for inviting me. I am very well. The weather in London is what we call champagne weather. It's very good. I'm really excited to be recording this podcast with you.
So does that mean it's just not raining for once?
Yes. I'm trying to be humorous in the English sense of the word.
Well, I shouldn't brag because I'm currently in Sydney at the moment recording this, and the weather has been spectacular, although we are actually in the middle of quite a heavy storm today and tomorrow. So the roles are reversed weather-wise.
Well, I think today we have an excellent opportunity to talk about a storm caused by the President Trump's tariffs, which were considered by our case.
Yeah. Well, that's definitely one way to describe it. I think we'll leave our political views to one side about what Trump may be up to and just focus on the actual decision. But as will become apparent in talking about this case from the U.S. Supreme Court, the majority of justices there had serious concerns with the legal basis for Trump's tariff program in the US. So we're talking, of course, about the Supreme Court decision of the US that was handed down about a week ago on February 20th, 2026. It was argued before the Supreme Court on November the 5th, 2025. The case is called the Learning Resources, Inc. Et al. Versus President Trump of the United States. And it's a decision from October term. And the citation is number 24-1287. So yeah, this is an interesting one, Andriy. What did you make of it?
I think that, in a nutshell, this decision is as interesting from a purely academic standpoint as it is consequential in practical terms. Because if looked at in isolation, the decision of the Supreme Court doesn't even talk about any remedies or any consequences of this decision, but that's what the industry has been racking their brains over, because the tariffs imposed under the statute that was in question in this case, they amount to something like $170 billion. And of course, now that the tariffs have been invalidated by the ruling of the Supreme Court, there are very lively discussions about potential reimbursements. Whether that is feasible, and also how that impacts on other tariffs which were imposed by Trump on other legal bases. For example, there are some tariffs which were imposed pursuant to several legal bases, citing several statutes, and one of those was the statute in question. So I think that this judgment it probably will give rise to subsequent litigation.
I think that's right. And of course, a lot of the press that there has been on this decision has focused in on what next. Well, the tariff program's been shut down. These tariffs were found to have had no legal basis for them, in which case the tariffs that have been collected, the taxes, the revenue that has been collected, the question is what happens to that? Should that all get reimbursed? How does it get reimbursed? Will companies ask for reimbursement and bring claims against the government? There's talk about whether certain companies will not want to be seen to be claiming back the monies. Other companies commercially may not have a choice about it. And so you're right. I think the consequences, ramifications, flow-on effects from after this decision are significant. And as you say, Andriy, are likely to lead to more litigation and discussion down the track. Today's discussion, though, in this episode will focus on the actual decision itself and go through, some of the reasons for why the authority that President Trump sought to invoke here to impose the tariffs was invalid. And of course, for any of you who have been tracking this decision, this won't come as a surprise to you, but the president called for or declared a national emergency with respect to two threats, as according to the president. The first of those being the influx of illegal drugs from Canada, Mexico, and China. And the second issue or foreign threat was the large and persistent trade deficits as described by the president. And he declared a national emergency with respect to both of those threats, deeming them unusual and extraordinary with the stroke of a pen. And he did that because he went on to then argue or declare that he was invoking his powers under the International Emergency Economic Powers Act, IEEPA, which is the act we're going to be talking about today, to impose these tariffs. So he essentially said, look, there's a national emergency. I'm invoking emergency economic powers here, and I'm going to impose these wide-ranging tariffs on just about every country in the world. So that's what happened. And yeah, would you like to pick it up from there, Andriy?
I think that to give some context to our viewers and listeners about this statute, IEEPA, it's worth reciting the relevant provision in full, because some of the argument developed by the court, and in particular Chief Justice Roberts, it focuses on the linguistics and how the provision is structured. So, as you said, when acting under this statute, the president must identify an unusual and extraordinary threat to American national security, foreign policy, or the economy, originating primarily outside the United States. And then he must declare a national emergency under the National Emergencies Act. And then follows a list of, I think, about 16 measures that can be taken under IEEPA, and those measures are as follows. The president may then, by means of instructions, licenses, or otherwise, take the following actions to deal with the threat: investigate, block to independency of an investigation, regulate, direct, and compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of, or dealing in, or exercising any right, power, or privilege with respect to, or transactions involving any property in which any foreign country or a national thereof has any interest.
Yes, that's a bit of a mouthful there. There's a lot of verbs that go into that provision, and I think, as the court has said, that the key words, there's two of them in that long list, and that is regulate and importation. And from those two words in amongst, and I think it's good to read them out, Andriy, because in amongst all those words, the government is arguing that the words regulate importation gives the government this wide-ranging tariff power, essentially. And yes, it needs to be connected to a national emergency, but it relies on the words regulate importation to argue that essentially gives the government a taxation power that does not need prior Congress approval.
Yes, that's absolutely right. I actually very much enjoyed the summary given by Chief Justice Roberts about the President Trump's position in this case. And the summary is followed by a very pithy answer that the court gives to the President's argument. And the summary is as follows. Based on two words separated by 16 others in Section 1702A1B of IEEPA, regulate and importation, the President asserts the independent power to impose tariffs on imports from any country of any product at any rate for any amount of time. Those words cannot bear such weight. I think even prior to unpacking the reasons given by the court, a common sense view would be that the Supreme Court was correct in denying the President's argument, because what Trump did was effectively what Chief Justice Roberts described. He sought to impose tariffs in all the countries in the world of unlimited duration and at any rate that he pleased. And the words regulate and importation, they seem quite vague to, I think, to any ordinary person. Something more concrete would be necessary to claim such monumental power.
Yeah, I agree with you, Andriy. I think that's right. And yeah, as you say, Chief Justice Roberts gave the leading decision here, and Justices Sotomayor, Kagan, Gorsuch, Barrett, and Jackson joined with him. Gorsuch and Barrett concurred, although they filed concurring opinions. Kagan filed an opinion concurring in part and concurring in the judgment, in which Sotomayor and Jackson also joined. And Justice Jackson cited to kind of legislative history in that justice's decision, concurring with Chief Justice Roberts and the others. Kagan, Sotomayor, and Jackson, they also took a kind of statutory interpretation approach, which is what you're going to there, and we can talk about that in a little more detail. But they found that you didn't need to look at the major questions doctrine at all. It wasn't necessary. You could just use ordinary tools of statutory interpretation to support the view that the government didn't have this tariff power. And Chief Justice Roberts' opinion, with which Gorsuch and Barrett agreed, gave, I think, quite a, as you say, if I may say, quite a neat summary of the reasons for why these tariffs got struck down. And in many respects, I think the court was quite strident in some of the reasons and the language used, with respect to the government, of course, and as appropriate. But it was quite a compelling read from my perspective, and indeed, Roberts's opinion is quite concise. It's not a super long decision. The whole decision goes for 170 pages when you pull in all the other justices' opinions. But if you're minded to read it through, I think Chief Justice Roberts' opinion is worth a read. It really kind of pulls it together neatly. And, I think the place to start on all this is separation of powers and the Constitution. And in the US, for those who are listening as US attorneys or US scholars or other US citizens who have learned about this from school, you'll know this probably pretty well, but and those outside of the US may not know it so much. But Congress is the arm of government that makes the laws. It's the one that has the power under the US Constitution for legislation. And the first clause of the provision in Article 1, Section 8 says that Congress shall have the power to lay and collect taxes, duties, imposts, and excises. It is no accident that this power appears first. Congress is the arm of government that has the power to tax. It's the most important of all the authorities that is conferred upon any of the arms of government. And the judiciary and the executive do not have the outright revenue-raising taxation power. And so if the executive is delegated power to make tariffs, to make taxes in certain respects, Congress has to delegate that to the executive branch. And this basic structure is very important to understand. We see President Trump and many other presidents before him present as though they have quite wide-ranging powers to make all sorts of laws, and they set the agenda and this and that. Actually, it's Congress that has the power to legislate. It's Congress who has the power, particularly to make laws with respect to taxes. And so the executive has to work within the delegated authority that Congress gives to it. And I think that's really the starting point.
Yes, look, indeed it is. And I think it's worth probably dissecting the opinion of Chief Justice Roberts in a granular fashion. So just like you, he starts with a basic premise that the power to impose taxes is vested by the US Constitution exclusively in the US Congress. And then he says that tariffs, trade tariffs, are by nature taxes levied on imported goods and services. And as such, the president has no inherent authority to impose tariffs during peacetime. Such authority can only be delegated to the president by an act of Congress. The delegation in question, he characterizes as what Trump is seeking to achieve is something that Chief Justice Roberts characterizes as distinct and extraordinary power to impose tariffs. The court says that such a delegation can only be achieved by clear words. This is where we come to something called in the US the major questions doctrine. And the doctrine is essentially that courts are very reluctant to read into ambiguous statutory text extraordinary delegations of Congress's power. And the court actually emphasized that this doctrine applies with particular force in this case, where the purported delegation involves the core congressional power of the purse. And Chief Justice Roberts gives a very interesting and I think appropriate example of where this doctrine has been applied previously. So not so long ago, during the cadency of President Biden, there was an attempt by the Secretary of Education to cancel $430 billion worth of student loans. This purported cancellation was based on very thin grounds. So basically, there was some statutory text that allowed the Secretary of State to quote unquote, waive or modify statutory or regulatory provisions applicable to financial assistance programs. And the Supreme Court was quite emphatic in its answer. It said that the relevant statute did not permit basic and fundamental changes in the scheme designed by Congress. Rather, the word modify must be read to mean to change moderately or in a minor fashion. It meant in practice that the Secretary of State could cancel the student debt of, say, a single borrower satisfying certain conditions, but not every borrower in the country. So I think a lesson that can be drawn from the present case and from the case of Biden against Nebraska, which was heard in 2023, is that the executive must tread very carefully when they're trying to assert exercise of certain power, which usually is vested in the Congress.
Exactly. And I think that's right. I think the court here was also making a bit of a point. I think because as we saw after this decision was handed down, President Trump didn't take too kindly to this decision, and he gave quite some negative commentary on what he thought about the decision and the justices that ruled against him. What the court's saying here, though, I think in perhaps not a not so subtle way, is this isn't personal, President Trump. We've done this before, and there is precedent here where the Supreme Court has ruled against Democratic executive arms in a similar way, to say that if the statutory text is ambiguous, then there is a reading against interpretations that would make that a wide, expansive delegation by Congress. Almost think of it this way: the more expansive the interpretation, the more express the words need to be. If Congress is going to give away powers that reside with it, particularly a revenue-raising power, its main power, so to speak, then there requires kind of clear words, clear delegation for that to happen. And the court here referred to a couple of other instances. You've mentioned there the Biden attempt to cancel $430 billion worth of student loan debt. And another case was West Virginia and EPA, where the Supreme Court declined to read authorization to determine the best system of emission reduction as a delegation of power to force a nationwide transition away from the use of coal. So in that case, the court did not allow a reading of the delegation that meant that there could be this nationwide movement away from coal, a kind of clean agenda, so to speak, or clean energy agenda, without that being clearly delegated to the executive. And then there was another decision in the National Federation of Independent Business and OSHA, where, again, that was in the context of authorizations to ensure the safe and healthful working conditions of, I think it was 84 million Americans, where the government sought to impose a vaccine mandate. And the government the court again in that case found that the ambiguous statutory text was not sufficient to show that Congress had delegated those powers to the executive. So it was interesting. I thought I kind of read the examples that the court had picked out here as being instances where it had shut down a democratic agenda, almost to say that, yes, we're going to shut down these tariffs, but we are doing so it's not the first time we've done that, and this is a fair reading of the law of the US.
Yeah, I agree. And I think so. The court actually explicitly says that, look, we're not trying to be partisan here. We're just humbly performing the function that is bestowed upon us by the Constitution, which is to check the exercise of executive power. And I think it is quite telling that I think three of the justices who ruled against Trump are Republican nominees. And if I'm not mistaken, at least some of them were even nominated by President Trump himself.
They were. So you're absolutely right. And as Chief Justice Roberts says in his opinion, you look at this from the perspective of constitutional structure and common sense. And he doesn't obviously just rest on common sense. But when you start from that position, a lot of the arguments that were run by the government and picked up in the dissenting opinions just don't have a leg to stand on. And so should we go through some of the other reasons then for why the court decided the way that it did?
Yeah, absolutely. So I think we've already covered the high level reasons, which were that the power of taxation is vested in the Congress, and very clear words are necessary to show that that power has been delegated to the executive branch, and applying the major questions doctrine. That test is not satisfied. But then the court, and in particular Chief Justice Roberts, he delves into some textual analysis of the words regulate and importation, and I think it's right that it's not necessary to resort to this major questions doctrine. It's just sufficient to look at the words, to look at the structure of the provision, to understand that this power is just not there. So the court emphasizes that the provision relied upon by the government gives a rather lengthy list of powers delegated to the president. And it is surprising that absent from this lengthy list of powers is any mention of tariffs or duties. And the court says that this omission is notable in light of the significant but specific powers Congress did go to the trouble of naming. It stands to reason that had Congress intended to convey the distinct and extraordinary power to impose tariffs, it would have done so expressly, as it consistently has in other tariff statutes. And the court says that the power to regulate importation does not fill that void. And it's interesting that the government could not point to a single instance in the US Code where the word regulate someone or something meant or included the power to tax. And so the court says that taxation may accomplish regulatory ends, but it does not follow that the power to regulate something includes the power to tax it as a means of regulation. And congressional practice suggests as much. It is quite notable that when Congress wishes to delegate the taxation power to the executive, it explicitly uses words like tariffs or duty. For example, there's a provision in the US Code in Section 16, which distinguishes between the power to, on the one hand, tax persons, franchise, or private property on lands, and on the other hand, the power to regulate the private lands. So here, the distinction couldn't be clearer. And I think the reason in this case is very congruent. It is, I think, self-evident that had the Congress wished to delegate the taxation, it would have said so in express words, like it has done, as the court as the court shows us with plenty of examples.
Yes, I think that's right, Andrei. There's some interesting points in there. And what was telling for me is that in the 50 years that, or whatever it is precisely, that IEEPA has been around, there has been no president that has invoked that statute to impose any tariffs at all, let alone tariffs of this magnitude and scope. And yes, presidents have invoked IEEPA regularly for other purposes, and the statute preceding IEEPA, but they've not used it to raise tariffs at all. And I thought that's quite a compelling point. It's not the end of the matter, of course, but you would think that in 50 years, if the executive presidents had known or had the view that Congress had clearly delegated tariff power to them, then they may have used that under this act. Well, I suppose President Trump and his advisors, executive, would say, well, we're just clever and we've come up with a new interpretation that others haven't. So that in itself is not a reason to say that the power doesn't exist. But that kind of, I think was quite interesting. I thought also that the invoking of a national emergency here for those two threats that I talked about at the outset of this talk as justification for such wide-ranging tariffs was problematic for the court. And I think the court, as comes through in a lot of these points, is that it wasn't targeted. Like you can imagine if there was something, perhaps even in that the US was in war with another country or something, and there was a particular national emergency related to that country, and the president took the view that some tariff had to be put in place in a targeted way to try and stop that importation or something like that. And it was targeted and narrow and specific to the national emergency that had been declared. The court may have been more sympathetic for the argument, but in a situation like this where the president has gone out and tariffed almost every country in the world in this blanket fashion and chopped and changed the tariffs, increased them to 145% against China at one point, and then dropped it the next day, and like this kind of, you could maybe say, cavalier or robust approach to tariff policy was, and for the government to justify that under a national emergency statute, I think caused the court a lot of problems with that.
Yeah, I think that probably it must have had some subconscious influence, I'll put it this way, upon the minds of the justices. However, the way I read the judgment is that they decided it as a matter of principle. I think that theoretically, even if the tariffs were sort of less dramatic, not imposed on any country, on every country in the world, and much more moderate in their degree, I think that the court would likely have struck them down as well, just because the delegation that the president claims is there isn't. And
I agree. I completely agree. I don't think, I'm not for a moment suggesting this is a policy-based decision of the Supreme Court, and I completely agree with what you're saying. I just think that context is what is kind of what the court's going to when it sets out the separation of powers in a very straightforward way. It refers to applying common sense here. It refers to ambiguous statutory text and cannot delegate such serious powers, with respect to taxes. And after all, a tariff is a tax, as the court expressly states here. And so, yeah, I think you're right. What did you make of the dissenting points? I know the court found none of them convincing. At least the majority of the court found none of them convincing. Were there any in there that you thought were worth touching upon?
Yeah. I think so. And there actually were a great number of dissenting points which basically replicated the government's argument. So the first one of those was that the doctrine of major questions should not apply to emergency statutes. And the whole point of such statutes was to provide substantial discretion to respond to unforeseen emergencies. But the court was quite uncharitable to that argument. So Chief Justice Roberts said that emergencies can afford a ready pretext for usurpation of congressional power. And he said that where Congress has reason to be worried about its powers slipping through its fingers, we have in turn every reason to expect Congress to use clear language to effectuate unbounded delegations, particularly of its one great power, in this case, taxation. One other rather interesting argument, which was mentioned in some of the dissenting judgments, was that courts should carve out an exception for cases touching on foreign affairs. This argument is interesting because it is well known that the president enjoys a very wide margin of discretion when it comes to foreign affairs. But the government itself admitted that the president and Congress do not enjoy concurrent constitutional authority to impose tariffs during peacetime. So Chief Justice Roberts, it's interesting that his judgment is replete with references to the framers of the Constitution, going back all the way to Alexander Hamilton and the others. And he says that the power of taxation was given to the Congress alone, notwithstanding the obvious foreign affairs implication of tariffs. And whatever may be said of other powers in foreign affairs, we should not expect Congress to relinquish its tariff power through vague language or without careful limits. One other particularly interesting argument was in relation to IEEPA's predecessor. So that was the so-called TWEA. And that is something that you mentioned, Luke. It also had the words regulate importation, and there was even a court precedent in 1975 which ruled that the authority to regulate importation in that statute gave President Nixon power to impose limited tariffs. The government said that when IEEPA was passed 2 years later, it meant to convey the same authority on the president without any limits. I think this is a good point, right? Because IEEPA was, as I understand it, the successor to that statute, TWEA, and it sounds sensible that the Congress would have wished the president to have the same power under IEEPA as he would have enjoyed under TWEA. But here's the catch: it's that the US courts only assume that a certain word in a statute has a certain meaning if there is well-settled authority on it. And the court emphasized that a single decision by a specialized intermediate appellate court does not clear that hurdle. So I think it's an interesting argument, but at the same time, it's just not persuasive enough for the Supreme Court. I don't know what the reasons were of that specialized court, but I'm just not convinced that one decision rendered under IEEPA's predecessor in 1975 is enough to give the president such wide-ranging powers that he claims, and also overcome all the common sense arguments that we have just been discussing.
Yeah, I can see that. I also liked this. Well, I like the way that the majority dealt with this other kind of contextual argument that was run, and that is to look at the word regulate. So remember, we've been talking about regulate importation in IEEPA, and the government's arguing that regulate includes the taxation power. There was one other point that I thought to touch on, Andriy, and that goes to one of the government's contextual arguments. And this is around the meaning of the word regulate. And I kind of like this one because it's the type of argument that a clever lawyer comes up with, so to speak, in that the government was arguing that regulate kind of contemplates a spectrum with two poles at the end of each end of that spectrum, one being on the affirmative end with the word compel, and on the other end, on the negative end of regulate, is the word prohibit. So to either compel someone to do something or to prohibit someone to do something. Those are the kind of two ends of the spectrum of what the meaning of regulate is. And the government was arguing that the tool of tariffs is somewhere less extreme and more flexible, and somewhere in between those two opposite poles. And so, it should fall within the notion of regulate, so to speak. And this, I think, was kind of what President Trump was saying after this decision when he came out in the press. I don't know if you caught this, Andriy, and was saying, well, I can shut down a whole industry, I can stop a whole importation from happening, but if I charge $1, if I ask for $10 for something, then I can't do it. That's a tax, and I can't do it. But I can block a whole country from trading with us, and because I decide to, and that's regulating importation. But I can't charge any money. And I think that that's President Trump's layman way of describing what the lawyers are saying here in this contextual argument of a spectrum across what regulate means. Now, what the majority of the court decided was that no, that's not the right way to look at it. The taxation power sits in parallel or outside of that plane. It's not within the spectrum of regulate. It's a different type of action that falls outside the spectrum entirely. And so I thought that was a neat play on language, but I found that one, an interesting read.
Yeah, I agree. And I think that is a very attractive argument. And I think that Trump, again, on their face, he made some really good points. The powers to compel and to, on the positive side, and to prohibit on the negative side can be quite far-reaching. So he can effectively shut down importation from whole countries. But it's not the problem. The problem is just that this argument is wrong in principle. It is that as you say, the power of taxation is vested in Congress, and that's the end of it. It's also interesting that the words to compel and to prohibit are stated expressly, and you can see why. To assert such power, they need to be stated expressly, and they are stated expressly. Unlike the word tariff, which again is a very far-reaching power, which is simply not there. I think if you consider the context of how tariffs are usually imposed, you can see that Trump's argument just doesn't work. I mean, it may be like emotionally attractive, but as a matter of legal principle, it just doesn't fly.
Yeah, I completely agree. Well, look, I didn't have anything else to add on that decision. It's obviously such a hugely consequential decision in the US, in global trade, and there were eyes all over the world looking at this decision. So I hope we've helped unpack that for our listeners, and thank you for listening in. If you've got any kind of questions on this, by all means, drop either of us a line. We'd be happy to talk about it some more. And as we mentioned at the outset of this this episode, watch this space. It's going to be very interesting to see what are the downstream consequences from this decision, and whether reimbursements get paid, how that all plays out. So there'll be more to hear on this. President Trump has also come out and reissued tariffs of 10% under a different power. So it'll be interesting to see whether that survives and how that all shapes out. But it's a fascinating area. We at the firm handle all sorts of disputes and projects in international trade, commodities, energy, and shipping. And so this is a sectors that we are working in, day out. And this type of activist tariff policy by the current US administration certainly keeps global players on their toes, and law firms like us that help guide market participants through. So thank you for your time, Andriy. It's good to have you on the pod again, and for unpacking this decision with us.
Thank you, Luke. It's been my pleasure.